American Commission on Human Rights. Thank you all for taking time out of your busy schedules to join us today. This event is being recorded, and the recording should be available on the Center's website at www.wclcenterforhr.org later today. My name is Hadar Harris, and I'm the Executive Director of the Center for Human Rights and Humanitarian Law at American University Washington College of Law. I'm filling in by making these introductory remarks today for our local human rights lawyering project director, Lauren Bartlett, who's currently out on maternity leave. Lauren will be back with us in January, but until then, we're keeping the project moving ahead and will be moderating the online briefing today. Before we start, let me give you just a bit of information about the project and the center. The Local Human Rights Lawyering Project works to normalize human rights at the local level here in the United States by providing training, coaching, and resources to local legal aid attorneys, hopefully soon also to public defenders, to help integrate human rights into their daily work. The Center for Human Rights and Humanitarian Law at American University provides scholarship and support for human rights initiatives around the world and in the United States. We work with students, academics, and practitioners to enhance the understanding and implementation of human rights and humanitarian law domestically, regionally, and internationally. We hold regular events and trainings, some of which are online only like this one for practitioners and law students, but many of which can be downloaded as resources for viewing remotely. Please visit our website for a list of past events and upcoming events. Today's webinar is extremely important in helping to provide input and insight and training into the important mechanism of the Inter-American Commission on Human Rights. The resources of the Commission have expanded in terms of the access that U.S.-based NGOs have obtained to seek remedies, to bring complaints, to file petitions over the past years. And as people become more aware of the mechanism, it provides yet another avenue for important human rights advocacy. Today, we'll have two presentations by knowledgeable experts in the Inter-American system, and we're pleased and very privileged to have both of them online with us today. Charlie Abbott is a staff attorney at CHIL, the Center for Justice and International Law. We're pleased to say that he received his Juris Doctor from the American University Washington College of Law and his BA in International Relations and Modern Languages from the College of William and Mary. He was a 2008 Fulbright Scholar at the National University of La Plata, Argentina, and prior to joining CHIL, he worked as a human rights specialist at the Office of the Special Rapporteur for Freedom of Expression at the Inter-American Commission for Human Rights. He has a wide variety and background of experience in litigation and advocacy work, including cases from the United States, the Dominican Republic, and the North Andean region. So he comes with a great deal of practical experience in bringing cases to the Commission as well as working inside of the Commission. Professor Carrie Bettinger-Lopez is an Associate Professor of Clinical Legal Education and the Director of the Human Rights Clinic at the University of Miami School of Law. Her scholarship, advocacy, and teaching concern international human rights law and advocacy, violence against women, gender and race discrimination, immigrants' rights, and clinical legal education. She focuses on implementation of human rights norms at the domestic level, principally in the United States and Latin America. She regularly litigates and engages in other forms of advocacy before the Inter-American Human Rights System, the UN, federal and state courts, and legislative bodies. She will speak about an extremely important case that she brought before the Inter-American Commission as an example and as a case study of the types of cases that can be brought forward. I also want to thank the Center's Program Coordinator, Michael Bainey, for his assistance in working the technology, which, as you'll see in a moment, is no small task, and fielding questions today. Speaking of questions, please feel free to type questions into the question box on your webinar screen at any time during the presentation. But note that we'll not be addressing your questions until the end of the briefing at approximately 12:50. Please note that we may not be able to get to all of your questions. Also, if you have any technical problems, which we hope you will not, please let us know by sending us a message using the question box or the chat box on your webinar screen. We will keep your microphones muted throughout the webinar. So with all of those preliminary remarks, the way that we're structuring today's webinar is we'll be showing some short video clips to lead into the presentations that both Charlie Abbott and Carrie Bettinger-Lopez will be making. And to start off our presentation today, we have a short video about the workings of the Inter-American system that we are crossing our fingers will work, and we'll lead off from there. So I'm going to dramatically say cue video.
In 3 regions around the world, governments have agreed to establish international institutions to monitor and protect human rights. One of these is the Inter-American System for the Protection of Human Rights, created by the Organization of American States. Engagement with the Inter-American System can be a powerful way of raising awareness about a human rights issue, giving victims an opportunity to be heard, and bringing about change. The system is made up of 2 bodies, the Inter-American Commission on Human Rights and the Inter-American Court of Human Rights. Each has different functions. The Commission monitors human rights conditions in all 35 countries in the Americas. It receives complaints, called petitions, to determine if a state has violated an individual or group's human rights, and to identify how the state should compensate the victim and avoid similar injustices in the future. The 7 commissioners visit countries in the region, hold thematic hearings on issues of concern, and publish reports on human rights conditions. The work of the Commission's rapporteurs helps it gain expertise and raise awareness in priority topics, including the rights of specific communities or groups. For its part, the Court issues judgments in complaints brought against states that have accepted its jurisdiction, but only when those cases are not successfully resolved by the Commission. 21 states have accepted the Court's jurisdiction. Both the Court and Commission can ask the government to take action to prevent irreparable harm to the subject of a petition or to an individual or community in immediate danger. These actions are called provisional or precautionary measures. The Inter-American System is not meant to take the place of national courts or to second-guess the decisions of local judges, so long as the domestic proceedings respected the parties' fundamental rights. The Commission and Court cannot decide individual guilt or innocence. Petitioners must generally try to resolve the issue using regular legal proceedings in their own country first. By using the petition system, requesting thematic hearings before the Commission, meeting with or submitting information to a rapporteur, and using the Commission's reports to educate the public, advocates can raise awareness of a human rights problem and increase pressure for governmental action. Often, engagement with the Inter-American System should be part of a broader advocacy strategy and should be followed by local efforts to monitor compliance, negotiate with the government, and make the affected community aware of the outcomes.
Okay. So my name is Charles Abbott, and I'm from the Center for Justice and International Law, and I have the distinct pleasure of joining all of you today to talk a little bit about the Inter-American Commission on Human Rights, advocacy before the Commission, what the Commission can do for advocates, and what to expect when bringing matters to the Inter-American Commission. At the outset, I'd like to give everyone my contact information in case you have any questions. At CEGIL, among other things, I have the distinct pleasure of being the attorney who works on the United States docket. So I often have the pleasure of interacting with local and national advocates for human rights in the United States. So if you have any questions as we go forward with this presentation that we aren't able to address today, please feel free to follow up with me off this call. So, a little bit about CEJIL, the Center for Justice and International Law. We were founded in 1991 by a group of human rights advocates in the region with the mission of bringing impact litigation before the Inter-American human rights system, which, as you just saw in the video, consists of the Inter-American Commission here in Washington, D.C., and the Inter-American Court in San Jose, Costa Rica. In addition to our impact litigation mission, we also seek to empower human rights defenders, including through presentations such as this one and trainings for national and local actors. We also undertake a large amount of political advocacy for strengthening the inter-American system, including during the most recent set of changes that happened to the Inter-American Commission in Court. So we've just seen a video about the Inter-American Commission, which kind of situates it within the context that it arises out of. But in a nutshell, the Inter-American Commission is a principal autonomous human rights body arising out of the Organization of American States, and it has jurisdiction over the OAS member states, including both those countries that have ratified the American Convention and those that have not. The instruments through which it derives its authority are the OAS Charter, which spells out that the Inter-American Commission has its jurisdiction over the 35 countries of the Western Hemisphere, the American Declaration of the Rights and Duties of Man, which is the principal document that you'll use to analyze human rights violations from the United States, and additionally the other instruments that have been created through the OAS member states, including the American Convention on Human Rights. And as you will see from our fellow panelists, from Carrie Bettinger-Lopez, in the case of Jessica Lanahan Gonzalez, among other important things, the Commission reiterated its long-standing jurisprudence that the American Convention can be used to analyze the American Declaration, but we'll get to that later. The main function of the Inter-American Commission on Human Rights is to promote respect for and defense of human rights. So what does the Inter-American Commission use to achieve these goals and these mandates it has under the OAS Charter? One is individual petitions, which to a large extent we will focus on during today's presentation. Another is precautionary measures. Precautionary measures are similar to injunctive measures or injunctions in domestic jurisdiction, and we'll speak about those a little bit as well. In addition to these quasi-judicial faculties that the Inter-American Commission has, it also holds public hearings. Some can be linked to individual petitions or precautionary measures, and others are thematic to examine general situations of human rights in the different states over which it has jurisdiction. It also issues reports. These include annual reports, thematic reports, and special reports. It holds on-site visits to the different member states and to specific places within the member states. For example, for its 2010 report on detention and due process in the immigration system of the United States, the members of the Inter-American Commission visited a number of detention sites, including in the southwestern United States, looking at the human rights situation there. Another way that the IACHR accomplishes its work is through rapporteurs, and we'll explain that in a second. They also use press releases and declarations to raise awareness about urgent situations as they arise and to bring attention to practices in the region. And they also monitor implementation, and that includes the implementation of their recommendations through the case system, which we'll talk about later. Now, to situate the United States within the Inter-American system, the United States is a member of the OAS, which places it among the countries that the Commission has jurisdiction over under the OAS Charter. But it has not ratified the American Convention on Human Rights. President Carter signed it in 1977, and since then it's been awaiting the advice and consent of the U.S. Senate, along with other important treaties. So for those of you who work in countries additional to the United States, perhaps in a different session we could talk about the particularities of countries that have ratified the American Convention on Human Rights and have accepted the jurisdiction of the Inter-American Court. But for today, we'll focus on the United States, which, like other countries, including Canada, Cuba, and a number of countries of the English-speaking Caribbean, are not party to the American Convention. Now, the Inter-American Commission is made up of an executive secretariat, which includes a large number of attorneys who work under the Secretary of the Commission, which is in the OAS building, and it also is made up of 7 independent and autonomous commissioners. Our current commissioners are Felipe Gonzalez, Rosa Maria Ortiz, and 2 are on the way out, who are Dinah Shelton, whose mandate ends at the end of this year, and Rodrigo Escobar Gil, whose mandate also ends at the end of this year. They'll be replaced by James Cavallaro of Stanford, who is from the United States and has been a practitioner for many years, and Paulo Vanucci from Brazil. The other commissioners are Rosemarie Belantoine, Jose de Jesus Orozco, and Tracy Robinson. It's worth mentioning that Commissioner Tracy Robinson, who is from Jamaica, is the country rapporteur for the United States. So the cases that you bring from the United States will be under her attention, and she's very keen to be in contact with practitioners. Now, for the Inter-American system, we have, as I mentioned, kind of different boxes under which you can understand how to send matters to the Inter-American Commission and get something out of them. On the contentious side, there are individual complaints and precautionary measures, which we'll focus on. But it's important to remember that these should be used in tandem, if possible, with the other mechanisms that the Commission has. They have a broad range of faculties, including these reports and other tools that I've mentioned. Now, about the IACHR's rapporteurships, they were established in response to the IACHR's specific interest in certain populations, including vulnerable groups. And their main role is to support the IACHR in cases in progress and to prepare the reports and monitor situations through their distinctive vantage points. And this includes processing cases. It also includes basically in every mechanism that you can imagine, including reports and on-site visits. They all have a role. And these are the IACHR rapporteurships, to put it in a, I guess, less technical way, is they are lightning rods for different ways that you can direct attention to important situations that arise. And these rapporteurships include thematic rapporteurs on the rights of women, on the rights of persons deprived of liberty, on the rights of migrant workers and their families, on the rights of children, indigenous peoples, Afro-descendants. There is a special rapporteur on freedom of expression named Catalina Botero, who is apart from the commissions, from the different commissioners, but has the same function, essentially, as of monitoring freedom of expression in the region. There's a rapporteur on human rights defenders, and additionally there is a unit on the rights of LGBTI persons. And this unit was created a few years ago, and it may become a rapporteurship eventually, but it's also an important place to direct advocacy. In addition to this, the different commissioners are all assigned to countries for which they are rapporteurs. So in the case of the United States, as I mentioned, that is Tracy Robinson. Now, for jurisdiction, to bring a petition to the Inter-American Commission, you'll need to show that it has jurisdiction, and largely this can be similar to domestic advocacy. This can be a recital that happens at the beginning and then is kind of spelled out in your petition itself. But it's much akin to the sources of jurisdiction in domestic advocacy. There needs to be jurisdiction over the subject matter, so subject matter jurisdiction, or ratione materiae. There needs to be jurisdiction over the parties to the litigation, so personal jurisdiction. There also needs to be temporal jurisdiction. In this case, it isn't as much a concern for the United States as it is for states that have signed the American Convention. when that's the case, you need to look at what the year of ratification was. But there also has to be jurisdiction over the place. So, for example, if something happens within the territory of the United States or territory under the effective control of the United States, such as the U.S. Detention Center in Guantanamo, the Commission has jurisdiction over the place. Now, for admissibility, a petition must be submitted within 6 months of the final decision of domestic jurisdiction. So this means that if you have a final decision from the Supreme Court or from an appellate court and there's no further remedy that you could exhaust, and we'll look at that in a second, then you should submit your petition within 6 months of the final decision you received, or within a reasonable time. And there's some specific jurisprudence about that, but for now we'll just spell out the 6-month rule as something to look for. Also, there's the exhaustion of domestic remedies, which I'll address more in detail on the next slide. Another requirement is known as litis pendens. All that means is that the Inter-American Commission requires you not to submit a contentious case before it and before a different international body at the same time. There are exceptions to this. For example, if it's a non-contentious proceeding, for example, a declaration from a special rapporteur of the United Nations, then that's a different type of proceeding. So litis pendens isn't a concern there. Largely, this won't come up in litigation, but it's something to keep an eye on. Now, for the rule of exhaustion of domestic remedies, the general rationale behind this rule is that the international system is complementary to domestic systems of protection. We want to make sure that domestic judicial systems are able to deal with human rights issues to the greatest extent possible. But when they can't, there needs to be an international system that can safeguard the rights that are spelled out in these international documents. So the criteria for interpreting this rule of exhaustion of domestic remedies is that in principle you should exhaust every available domestic remedy before coming to the Inter-American Commission and submitting a petition. However, this should not lead to a halt or delay that would render international action ineffective. There's the principle known as effet utile, or the useful effect of international jurisdiction, which means that a state can't hold up delays in its own procedures as a justification for leaving someone defenseless. So there are a number of important exceptions to the rule of exhaustion of domestic remedies, all springing from this general criteria. Now, generally, the domestic remedies that you must exhaust before coming to the Inter-American Commission with a petition must be judicial. They generally must be ordinary remedies. That is to say, they shouldn't be extraordinary remedies. Now, certiorari, for example, before our United States Supreme Court is very unlikely to be granted, and the Commission has held it not to be an ordinary remedy. It's extraordinary. On the other hand, an appeal from a trial court, unless it's plagued by delays, is an ordinary judicial remedy that should be exhausted if possible. Now, domestic remedies must also be adequate in order to be required to be exhausted. So they must be suitable to address the exact legal right that is the subject of the international petition. So not all remedies are applicable in every instance, and if a remedy isn't adequate in a specific case, you don't need to exhaust it. Finally, a domestic remedy that must be exhausted must be effective. So it must be capable of producing the result for which the remedies were intended. So it's not effective if it is pointless to exhaust it. If it's powerless to compel authorities to do something, it needn't be exhausted. If it presents danger to the people who use it, then it needn't be used. Also, if it's not impartially applied, then it doesn't need to be used. So I'm sure that many of you can think of everyday situations which would not require exhaustion of domestic remedies. Now, finally, Some more reasons that you wouldn't need to exhaust domestic remedies include domestic legislation not affording due process of law, the party alleging the violation being denied access to the remedies under domestic law or being prevented from exhausting them, or unwarranted delay. Now, the Commission generally considers cases in two stages. First is admissibility and then is merits. You can request for them to be considered together, but the general practice is to first have an admissibility decision and then a merits decision. Before even it reaches admissibility, as I'll show you in a flowchart in a few slides, before reaching admissibility, when you first submit a petition, it goes to a group known as registry. This group checks that it meets all of the formal requirements, so kind of similar to looking at whether a brief is, contains all facts that, if proven true, would spell out a case. Now, for admissibility, this is just to determine whether the allegations, if they were true, would have a case under the American Declaration. So, for admissibility, what you seek to show is the state's international responsibility would fall under the Declaration, and here the Commission includes direct evidence. It includes circumstantial evidence, including presumptions, so long as it's possible to infer conclusions consistent with the facts. So there's a very broad evidentiary standard under the admissibility rules for the Commission. So how might you speed up a case? This is one of the most frequent questions that I get. And you can look to Article 29 of the Commission for that. There are a number of reasons that are now spelled out. So the admissibility procedure is basically this, what I just mentioned. You submit your petition within 6 months. It's transferred to the state answers, and then it either is declared admissible or inadmissible. Now, proceedings on the merits, once you get an admissibility decision, you'll begin your brief on the merits. The state will have to respond to it, and during this initial time, right here, you can submit a request for a friendly settlement, which is a different matter that is also worth looking at. Finally, you can expect a decision on the merits under Article 43 of the Convention. Now, the precautionary measures, as I mentioned, are injunctive measures, and unlike petitions, they don't require previous exhaustion of domestic remedies. But you do need to show that domestic action or inaction is for a reason. All you need to show for precautionary measures requests are that they are serious and urgent cases, it's necessary to avoid irreparable harm, and that the denounced facts are credible. And the credibility is kind of a prima facie standard. And this is all spelled out in Article 25 of the Inter-American Commission's Rules of Procedure. Now, finally, let's look at some positive outcomes from international human rights litigation. We're all here for a reason, and that is that we want to see what we can get out of the Commission that we can't get out of domestic litigation. Some possible outcomes, and we'll see this more in detail with Carrie's presentation, are to involve member states in dialogue, create spaces for coordination or movement building, provide redress to victims and family members, create awareness of an issue, change patterns and practices. We can think of a number of important changes that we'd like to affect through this international advocacy. Now finally, and I'll just leave these for our consideration as we continue, there are a few challenges that we should think of as well. Representation is an issue, especially if you don't have direct contact with one of your clients. Backlog. There's a significant backlog of cases before the Inter-American Commission, which has very limited resources and deals with a very large amount of petitions every year. The costs. Now, the implementation of judgments are also a challenge, and we'll talk about that also with this concrete case that Carrie will bring to us. And finally, to give you kind of a practical idea of what you might expect in Inter-American Commission petition proceedings is, unless you find a way to speed them up, they can take about 8 to 10 years on average from the initial submission of the petition to a final judgment. That's on average. So you have to carefully weigh how to use the different mechanisms that the Commission provides in tandem to create the best cumulative effect possible for your client or for the situation that you're trying to remedy. So with that, I'll conclude my presentation, and I will turn over the microphone to my colleague, Carrie Bettinger-Lopez.
Just before you do that, this is Hadar again. Thank you very much, Charlie, for that great presentation and very swift trail through the Inter-American Commission. Just so people know, the video that was played before is from the International Justice Resource Center, and they have some great resources available at IJRcenter.org. We will be posting that together with a copy of this presentation on the website later today or tomorrow morning. With that, I'd like to throw things over to Carrie Bettinger-Lopez, who's going to give us a concrete example of the system at work, the good, the bad, and the ugly. And to start that presentation out, we have a short video that will lay out a key case that Carrie was involved in, the case of Jessica Lenahan. So, Carrie, if you would like to cue the video. Yep. Okay. You're online, and you can cue the video. Everyone will be able to watch that. Also, for the people who are online, we may be going a few minutes over. We try our best not to, but we did start a few minutes late. So at this point, Carrie, you tell me when you're ready.
Okay. Hi, everybody. This is Carrie Bettinger-Lopez. I'm going to start out with a brief video about the case study that I'll be discussing, which is the case of Jessica Lenahan Gonzalez versus United States.
Hi, I'm Jessica Lenahan. I'm the petitioner in the case of Jessica Gonzalez versus the United States of America. My life's work is to educate Americans that protection from domestic violence is our human right. I was born and raised in Pueblo, Colorado. I'm Native American and Latina. I met Simon Gonzalez when we were children. Through the years, we saw each other off and on and eventually got married in 1990. We had 3 daughters, Rebecca, Catherine, and Leslie Gonzalez. Slowly but surely, just became very controlling in what I wore and who I spoke to, and it slowly crept in over the 10.5 years that we had a marriage. And he started acting really erratic, and threats of wanting to kill himself and threatening his neighbors, I'm going to die, you're going to die, somebody's going to die. He actually tried to hang himself in the garage in front of my children at one time. When you're a victim, you try to portray this life like it's fine, like there's nothing wrong. But when my children were starting to become affected and become frightened of him, I just decided that we're just going to tell the truth. And no matter how painful or shameful I felt at that time, that it was really necessary to do whatever I needed to do as a mother to protect my children. In 1999, I decided I needed a restraining order, that it just got so dangerous for the children. I went before the judge and explained what was going on within my home, and the judge realized that Simon was a danger to me and the children, and that he needed to not be a part of the home at all and needed to stay at least 100 yards from the household itself. On June 22nd, 1999, Simon violated the restraining order by kidnapping the girls from my front yard. I called the police, and dispatch was supposed to send a car out, and I waited hours before they came out, and I called again. I'd given the officers the restraining order when they arrived. And they decided that because Simon was their father, that the children would be fine and they didn't have to look for them. I shouldn't worry because they were with their father. But all in all, they just, throughout the evening, didn't look for them at all. They were very dismissive of any requests I made and belittling to me for even asking them for help. They called me ridiculous at one point. I contacted the police 9 times altogether, twice in person, and 7 times over the telephone. At 3:20 in the morning, Simon pulled up in front of the police station after buying a gun and opened fired on the police. And they fired back. Simon died, shot him dead. And then they found the bodies of my 3 children shot to death in the cab of the truck. Eventually, it went to the highest court in the land, which was the Supreme Court. The United States Supreme Court said that I had no constitutional right to police protection or enforcement of my restraining order. So if restraining orders are not enforced, then they're not worth the paper they're written on. I filed a case with the Inter-American Commission on Human Rights because my human rights were violated by Castle Rock, Colorado for not enforcing a restraining order to protect my children and myself. And my human rights were also violated within the court system for not providing a remedy.
I deserve answers, and I deserve to know the truth. I want to know why the police ignored my calls for help. They've been asking these questions for 9 years, 9 long years. How long will it take for you to help me discover the truth? I know I cannot bring my children back from that night. The emptiness I feel when I remember my daughters and the great lives they might have lived. Nothing can bring them back. Nothing. What I can do, however, is to be a voice for the voiceless and women who are promised protection in America and then denied it in the moment they're in danger.
By deciding in my favor, the Inter-American Commission has recognized that the United States allows human rights violations to continue against women and children. These are the facts and the statistics in our country. 1.3 million women are physically assaulted in the United States by an intimate partner each year. Every day, approximately 3 women and 1 man are murdered in the United States by an intimate partner. Every year, 3.3 million children are exposed to violence against their mothers or their female caretakers. Every day, approximately 4 children die from violence in the home. There are preventative measures. I believe education starting from very young will prevent violence, domestic violence, violence against women. All in all, it's not up to the Commission to change the U.S. It's up to United States citizens to decide to change this world for themselves. They can give us all the tools, but we have got to be able to embrace and put them to use. Our society traditionally thought of domestic violence as something that happened behind closed doors and that it was nobody else's business. But it is our business, and it should be our government's business too. Our government can't turn a blind eye to this human rights violation. It's happening right under their noses. Our country has an obligation to stop domestic violence in its tracks.
Okay. So that is my client, Jessica Lenahan, telling the story of her tragedy and her quest for justice in her own words. And right now I want to just run through and highlight a couple of the themes that Charlie mentioned about how Jessica's case made it from federal district court in Colorado through the Inter-American Commission on Human Rights. I just want to highlight the headline in this newspaper article because I think it's very important to underscore the fundamental problem that we were seeking to tackle in the Inter-American Commission case. The headline reads, "Man dies in shootout, daughters found dead." And indeed, we oftentimes, when we think about domestic violence in this country and the way it's portrayed in the media, is portrayed as some sort of private affair. We hear about words like domestic dispute, and we don't think about domestic violence necessarily as a human rights violation. Our minds typically wander when we hear the words human rights violations to problems out there, somewhere else in the world, problems that are described as grave, systemic human rights violations like extrajudicial executions or torture in places of detention. And part of what Jessica's case challenges us to do is to transform our thinking about what constitutes a human rights violation, to think about the things that happen behind closed doors in the intimacy of our own homes, and in fact address some of the most some of the vast majority of can affect a large majority of people. I'm just seeing, sorry, a note that there is a problem with the centering of this. Let me take it off full screen. Okay, I hope people can see this. I'll find out in a moment. Okay, I'm going to keep going. The language of Jessica's restraining order, I just want to underscore, said that a police officer shall arrest or shall seek that a police officer shall seek a warrant for the arrest of the restrained person. And this language of the restraining order echoes Colorado's mandatory arrest law, which gives a concrete directive to law enforcement to make an arrest. The specific legislative history indicates that this was done to avoid the historic problem of police ignoring domestic violence calls and telling abusers, take a walk around the block, splash some water on your face, that law enforcement did not see domestic violence as a fundamental problem. So I'm going to just skip ahead in the interest of time. In addition to this attitude of law enforcement not taking domestic violence seriously, we really see that reflected in the quote at the bottom of the screen from the chief of police. So we see the stereotypes and misunderstandings of family violence dynamics in this quote that the police chief gives: "What safer place could children be than with one of their parents, the mother or the father?" And then we see this attitude reflected when her case gets up to the U.S. Supreme Court, where Justice Scalia, in a 7-2 decision, finds that the words "shall" in her restraining order, the police shall arrest, don't equate to mandatory language. And so you have this Supreme Court decision saying that "shall" doesn't mean "must." And many people saw this decision as disingenuous at the very least, and as yet another knock for domestic violence survivors, women, children, the people who are typically, as the statistics that Jessica read in the video, the people who are typically the victims of family violence. And women's rights groups, domestic violence groups, civil rights groups were outraged. They felt like that this decision sent a message that restraining orders don't have to be enforced and fostered this culture of impunity. Left Jessica deprived of her day in court. I'll just note that her case went up to the Supreme Court on a motion to dismiss, which meant that she never had a chance for any evidentiary testimony. And many in the U.S. thought, well, it went to the Supreme Court. Where else could we go to seek justice? It went to the highest court in the land. As Charlie mentioned, the Inter-American Commission was the place that Jessica's lawyers, a legal team that consists of the ACLU, Miami Law Human Rights Clinic, and the Columbia Law Human Rights Clinic, we focused upon the Inter-American Commission of Human Rights for the precise reasons that Charlie discussed. The opportunity that the Commission gave for Jessica to seek some sort of justice when she has exhausted her domestic remedies to the highest court in the land and gotten a decision against her. I want to highlight the distinction between U.S. jurisprudence and international jurisprudence. The famous case of DeShaney versus Winnebago County in U.S. law, many of you are probably familiar with, which basically finds that the government has no duty to protect individuals from private acts of violence, even when there's a clear and preventable threat. And of course, this is not on the slide, but we also have equal protection jurisprudence, which requires showing of intent in order to prove discrimination under the 14th Amendment. So the cards are really stacked against a person like Jessica, who's trying to hold the police accountable under the federal Constitution. And the legal theory that she brought her case under, I can discuss in more detail during the Q&A, but it was a procedural due process theory, arguing that she had an entitlement to have her restraining order enforced under the 14th Amendment procedural due process provision. And there she lost as well. So contrast these decisions with the international law standard. This is a classic formulation from the Inter-American Court of Human Rights, as well as the European Court of Human Rights. The Inter-American Court first articulated this standard in the famous Velazquez-Rodriguez case, which I'll get to in a moment. Basically says that state responsibility ensues when the state knows or ought to know of some real and immediate risk to an identified individual by another person and fails to take reasonable steps to prevent the harm. So that case is here at the top of your screen, Velazquez-Rodriguez versus Honduras. That was a seminal case that set this standard on what's called due diligence, the duties to protect, prevent, investigate, punish, and compensate when human rights violations occur. And if the state fails to undertake its due diligence obligations, then Velazquez-Rodriguez says a petitioner can take the case up to the Inter-American Commission, and if the state has acceded to jurisdiction, to the Inter-American Court. And this follows other jurisprudence and law has developed from other international human rights bodies. Here I have the CEDAW Committee, the Committee on the Elimination of Discrimination Against Women at the UN, which has picked up on this approach as well. I'm not going to get into this famous case of the cotton field or Campo Algodonero case, but I highlight it and commend it to you. It's a wonderful case from the Inter-American Court on Human Rights that follows through on some of these principles about violence against women committed by private actors and the affirmative obligations of the state to protect and prevent. Getting back to Jessica's case, then, in light of all of this jurisprudence and these approaches that I discussed, the Inter-American Commission found 4 different rights violations in her case. I have them here. Violations of the rights to life and personal security of the children, violations of Jessica's equal protection rights and her right to non-discrimination. Very important. The Commission makes this link between gender-based violence being a form of gender discrimination. And this is really the first time that we're seeing the Commission make this link with respect to the United States. Article 7, Special Protections for Children. The Commission uses the best interest of the child standard, which, as I'll discuss in a little while, it might be very useful for those of you who are family law practitioners to think about how you might incorporate it into your family court cases. And finally, the right to judicial protection and due process, the right that you have to petition your government and receive a response to your request for assistance. So just to underscore, there were kind of 3 different areas here that we alleged were violated by the United States. Of course, the United States being the respondent country because the case had gone up against the town of Castle Rock and we had lost, and so, as Charlie discussed, the national government becomes accountable at that point. The failure to enforce the restraining order, to protect the lives of the daughters, and on a systemic level, the failure of our government to protect from really an epidemic of domestic violence in this country. I have here several quotes which I'm going to briefly skip over because of time, but you see the language of due diligence that I just mentioned with respect to private actors, preventing, investigating, sanctioning, offering reparations for private acts of violence against women. You see this language specifically with respect to discrimination and equality, and you see that the Commission hones in on the fact that discrimination affects different people differently, and so gender discrimination might have been combined with other forms, multiple forms of discrimination in Jessica's case, and this is an important development in international law where we're seeing kind of this concept of intersectionality developing in international jurisprudence. The Commission says very importantly that the state must reform its practices and take steps to modify patterns of conduct that reify different stereotypes for men and women, and the Commission discusses the importance of adequate and effective judicial remedies. Again, that language that you saw in Charlie's presentation. There were 7 recommendations that came out of the Commission's decision, 3 of which had to do with individual remedies and 4 of which had to do with policy reforms. And so the individual remedies had to do with investigations and reparations for Jessica, and the policy remedies had to do with law reform on protection orders that they actually must protect victims from violence, as well as children in the domestic violence context. This addressing stereotypes language that was just discussed was a key part of the Commission's recommendations as well. And so I want to suggest that as we think about where Jessica's case becomes useful, we look at her case as a case study in what I might call bidirectional advocacy. So outward facing, meaning how can we take our domestic social justice problems and place them in terms before international fora. And likewise, inward facing, when we get judgments or when we have case law developments or other normative developments at the international level, how can we incorporate those into our own advocacy here at home? And Charlie mentioned some of these, but here's a quick set of areas in which you as domestic social justice practitioners might consider using the Inter-American human rights system or other international fora in this outwards-facing advocacy, taking the issues that you see, whether it's bread and butter injustices that you see every day, whether it's in a courtroom or on the streets, dealing with different governmental agencies, or otherwise, how you might take them to the international level. I'm just going to skip ahead. And then likewise here, bringing it inwards. How might you bring these concepts to the fora that you probably the majority of the people in this call practice in primarily. So whether that's using international law concepts in your amicus briefs, dropping it as a footnote, creating expert affidavits or reports, using it in legislative and policy advocacy or trainings, putting political pressure on your local or state or federal elected officials, contributing to op-eds or other public education campaigns, perhaps a education campaign in your school, and thinking about using the language of human rights decisions in coalition and movement building. These are all ways in which we have considered using the Jessica Lenahan case and have taken some steps. And so I'm just going to wrap up in my remaining few minutes highlighting two places, one at the federal level and one at the local level, where we have sought to use the language from the Lenahan case, and where some places where we've actually had some forward movement. So many of you may be familiar with recent investigations by the Department of Justice into the Puerto Rico, New Orleans, and Maricopa County police departments engaging in patterns or practices of discriminatory and unconstitutional policing. And many of these investigations resemble traditional DOJ investigations into law enforcement. They're pretty comprehensive in scope, but one of the new things that's been really remarkable that has developed since the Lenahan case is that the DOJ is now investigating gender-biased policing in response to domestic and sexual violence. Now, the DOJ will never say that they're doing that because of the Lenahan case, but we feel like the case, and we've been told by folks inside DOJ, the case has placed domestic and sexual violence on DOJ's radar in a new way. And so this is the type of way in which we might see kind of the normative infusion of international human rights coming into our executive agencies in this case, and perhaps, hopefully, affecting the way they do their business. The investigation's conclusions find a pattern and practice of general discrimination and specifically focusing on response to domestic violence and sexual assault. We have proposed Department of Justice guidance on law enforcement response to domestic and sexual violence, hoping that the approach that the DOJ has taken towards those investigations at the local level could be translated into a guidance document that could be disseminated to law enforcement nationwide. And on the other hand, at the local level, several law clinics have taken up the idea of incorporating the principle of the Lenahan decision that freedom from domestic violence is a fundamental human right, and recognizing that in local resolutions that cite to the Lenahan case, that cite to various United Nations documents, we've seen those crop up in a handful of cities across the country. And here's an example of language that our students here in Miami crafted for the Miami-Dade County resolution that's amongst the strongest of these resolutions. It serves as a charge to all local government agencies to incorporate these principles into their policies and practices. So we have these very interesting resolutions now and this charge here in Miami. And we're at the point now where we're trying to figure out, well, how do we translate this into real policy changes at the local level? So we're focusing on various levels, municipal, state, and federal. And I'll just end by talking about two places that advocates are working on to implement these freedom from domestic violence as a fundamental human rights, resolutions. In the housing context here in Miami, we're looking at places where state-subsidized housing is not necessarily subject to the housing provisions of the Violence Against Women Act, which require the transfer which require the housing authority to permit the transfer of for domestic violence survivors if they are being subject or threatened with domestic violence, and several other provisions. We're looking to extend those provisions to the state level for state-subsidized housing or the local level using this resolution. Likewise, in Maryland, folks there are looking in the child custody context. There's a statute in Maryland that says judges shall consider domestic violence evidence when considering the best interests of children in custody disputes, but that shall consider language is quite loose and has not been oftentimes respected by judges in a way that advocates feel is adequate. And so advocates are pushing judges to interpret shall consider as heavily weigh, again citing to the domestic violence and human rights resolution. So those are a couple of places where we've looked to translate the Lenahan case into actual policy changes at the local and federal levels. And I'm happy to discuss all of this more, but in the interest of time, I'll take a break here.
Thank you, Carrie, and also thank you, Charlie. Clearly, 1 hour for an overview of the Inter-American Commission, the ways in which to bring a case, and the ways in which to have impact from a case like the cases that were discussed today is much too little time. Much too little? It's far too little time. But I think that we've had two very rich presentations. We will hopefully be able to post the PowerPoint presentations with the permission of the speakers along with the videos and the link to this webinar a bit later today or tomorrow morning. At this point, we are just about out of time. We've had several questions, one of which, though, I think was well answered by Carrie's strategic outline about how the Linehan case was operationalized in a way that really moved implementation forward. So we acknowledge that there was a question about strategy, how you bring a case forward, how you use a case, and how you can move a case further. One quick question that either Charlie or Carrie could answer is about fees. At one point, one of the challenges that Charlie had laid out was costs. And so there was a question about whether there are extraordinary fees or how much the fees are to bring a petition to the Inter-American Commission. Either of you to answer?
This is Charlie. I'd be glad to take that question. Actually, there are no, the Commission requires no fees. It is a free forum. What I referred to with costs is rather the cost of going to Washington, D.C. for a public hearing if you go there, for the time spent creating the petition and briefing the different issues in the case, but there are no fees. It is a free forum. And additionally, there is a legal assistance fund available at the Commission in addition to the court for transportation of the affected people, of your clients.
Right, great. Thanks, Charlie. In the interest of time, as I see that people are starting to sign off, we're going to ask that anybody who has questions, additional questions, can email us, and we can certainly put you in touch with the speakers themselves, and we can continue this discussion. At this point, I really would like to thank very much Charlie Abbott and Carrie Bettinger-Lopez for their very rich presentations. 1 hour isn't enough, but it gives you ideas and inspiration to learn more. For more on possible ways in which to integrate human rights in the U.S. and to make human rights arguments before U.S. courts and policymakers to help integrate human rights into U.S. law, I would urge you to look at several different kinds of resources. The Local Human Rights Lawyering Project, which we run through our center, has a handbook for legal aid attorneys in the United States, which is available for download through our website, www.wclcenterforhr.org. And I would also encourage you to look into joining the Bringing Human Rights Home Lawyers Network, which is run through the Columbia Human Rights Institute at Columbia Law School. So thank you again for participating. Thank you again for being part of this webinar series. We'll be announcing the next webinars coming up in January soon, and we look forward to continuing this ongoing conversation with all of you. Thank you so much, and have a great day.